Right. I think we'll make a start now. There's more people still coming in. So good afternoon, everyone, and welcome to this webinar. My name's Rob Starr. I'm a partner in the regulatory team at Howes Percival, and I've been dealing with fire safety matters for over 15 years. We provide advice to people who have issues with fire safety, but we also engage with enforcing authorities to do things like appeal of enforcement notices, and where it really unfortunately goes to the wire, we assist people with defending prosecution. So lots of experience in fire safety. And I'm just going to spend sort of 25 to 30 minutes just to have a quick canter through recent developments in fire and some elements of building safety. Now, I've included the Building Safety Act towards the end of this presentation. It's probably quite optimistic that the Act is so vast that actually in pulling this together, realised that we probably don't have time to do anything other than just scratch the very surface. So this is what we're going to have a look at today. So, as you will probably be aware, the governing legislation for fire safety is the Regulatory Reform Fire Safety Order, and I'm just going to call it the Fire Safety Order moving forward. And this sets out the main fire safety duties and obligations that are held by a responsible person or other duty holder. It includes things like ensuring that a suitable and sufficient fire risk assessment is undertaken, and also making sure that any responsible person makes and gives effect to appropriate fire safety arrangements and ensures that things like maintenance and repair of essential firefighting and fire detection equipment is undertaken. Now, it's a big piece of legislation and we can't go through all of the duties today, but the duties, primary obligation for compliance with the duties falls to what's known as a responsible person. Now, under Article 3 of the order, that defines who a responsible person is, and it's a hierarchical system. So it starts off, if the premises are a workplace, then the responsible person will be the employer. And you can have more than one responsible person in connection with a set of premises. But given the nature of the people that are coming in today, obviously we're looking at property, we're looking at accommodation, etc. It's likely that it won't be a workplace. So we're looking at the other categories of responsible person. So the next is somebody who has control of premises, either as occupier or otherwise in connection with carrying on of a business, or alternatively the freehold owner of the premises. Now, the duties aren't confined just to a responsible person. Other duty holders can exist in relation to a set of premises. So under Article 5.3 of the Fire Safety Order, the duties can also apply to anybody else who has control of the premises to the extent that matters are within their control. Now, that can include, for example, somebody who has obligations of maintenance and repair in respect of a set of premises, but it can also be somebody, for example, who has control imposed on them by virtue of a contract. Now, this occurs under Article 5.4 of the Fire Safety Order, but may include somebody, for example, like a building manager. It could include a tenant, but it could also include somebody who is engaged to undertake a fire risk assessment, maybe from an external consultancy, or a company who is engaged to maintain alarm systems, for example. And those duties will only apply to the extent of their control. So if somebody came in to do a fire risk assessment, they couldn't be criticised or have an allegation of a breach of duty if there was a failing elsewhere, for example, in relation to the alarm system. Excuse me. Now, the fire safety order, again, it relates to workplaces, etc., and it also applies to, in terms of accommodation, it will apply to buildings where there are two or more sets of domestic premises, and in particular where there are communal areas within. So there may be means of escape, protected corridors, etc. So it doesn't apply to single houses sort of on their own, single set of domestic premises, and it's not intended to apply to, for example, semi-detached houses and accommodation, which technically you might think would fall within that description. The other thing to bear in mind is that domestic premises are outside of the scope of the fire safety order. So by way of example, in a multiple occupancy block of flats, the actual single flat dwelling, anything behind the front door of that flat is outside the scope of the fire safety order, other than any equipment that is in there to protect people outside of that flat. So that may include things like smoke or fire detection alarm systems. Now, the overall scope of the fire safety order has long been subject to debate, and some of elements of that have been clarified recently with the coming into force of the Fire Safety Act 2021. Now, this was introduced, became effective in May last year, and that clarified the scope of Article 6, which deals with the overall scope of the fire safety order. And that confirms that where you do have a multiple occupancy building, so 2 or more sets of domestic premises contained within a single building, that external walls and anything attached to those walls, so that might include windows, external doors, balconies, and in particular cladding systems, they fall within the scope of the fire safety order. The building structure itself falls within the scope of the order, and as has long been recognised by most fire safety professionals, the actual flat entrance door itself falls within the scope of the fire safety order. Now, when you think about it, the overall purpose of the flat entrance doors is to protect from fire and from smoke going into a protected corridor or a communal means of escape. And so it would make sense that those flat entrance doors fall within the order and have to be maintained and kept appropriate. So that were the changes introduced by the Fire Safety Act. And having said that most of what we're dealing with today and talking about today relates to 2 or more sets of domestic premises within a single building, this one is slightly different. So this may have been on your radar, but it certainly, most clients I've spoken to, it sort of snuck in. So there have been amendments to the smoke and carbon monoxide alarm regulations. Now, this was a 2015 set of regulations, and historically it didn't apply to registered providers of accommodation, but they've been amended and updated. And from the 1st of October last year, the smoke alarm regulations now apply to all immediate landlords of a specified tenancy. Now, what they require is that at least one smoke alarm is fitted for every floor of living accommodations. So that would include if there's a bedroom upstairs and kitchens, etc. downstairs, you would need at least one per floor. And that you have to fit a carbon monoxide alarm in any room where there's a combustion appliance. Now that excludes gas cookers, but any other room. The other sort of newer duty that has been introduced by the amendments is that a landlord must ensure that any faulty alarms are repaired or replaced as soon as practicable after being informed by the tenant. Now, historically, the only requirement was that the landlord had to ensure that the alarms were in good working order from day 1 of the tenancy, and this is therefore a fairly significant change. Now, if the duty holder under the regulations fails to comply with these obligations, they can be served with a remedial notice by a relevant housing authority. And in the event that they fail to comply with that remedial notice, then the housing authority can issue penalty notices. Now, the penalties can be up to £5,000 per breach, so fairly significant and can be aggregated. Excuse me. Now, earlier this year, the Fire Safety England regulations came into force, and these should be something that you are familiar. They did receive quite a lot of publicity at the time they came in. And the overall effect of the regulations is to implement many recommendations that fell out of the Grenfell Tower inquiry phase 1 report. And the overall effect of the regulations is to try and provide more information to fire and rescue services in order that they can sort of plan either before they may have to come and provide emergency assistance, or at the time of responding to a fire incident. Like the fire safety order itself, it applies to multiple occupancy residential buildings, those with common parts, but there are different regulations that apply depending on the height and type of building. So the taller the building gets, the more regulations that actually apply to it. Now, the regulations have been introduced under Article 24 of the Fire Safety Order, so it doesn't affect any of the fire safety order. The key safety duties that are there, that have always been there, will carry on applying. This is over and above those. But what that means is that if you fail to comply with the regulations, then and such a failure puts one or more persons at risk of death or serious injury in the event of a fire, that's an offence and you can be prosecuted for it. So what do the regulations do? Now, in relation to premises of any height, so again, multiple occupied premises where there are two domestic residences within a single building, there is an obligation to provide certain information. So under Regulation 9, you have to provide information about fire safety instructions. So that is, the resident needs to understand how they can report a fire, what the evacuation strategy is for the building, and any other instructions that tells those residents what they must do when a fire has occurred. So, for example, if it is a stay put strategy, what that means; if it is a simultaneous evacuation, what that means, and how they go about it. Now, those instructions have to be clearly displayed in communal areas, and they need to be shared with residents once they move into the building. And also you have to continually refresh this. So you should provide the information to residents at least annually. Any updates to the information, any significant changes also need to be notified to the residents. Now, in addition, Regulation 10 introduces a number of obligations in relation to fire doors. But as far as information is concerned, you have to provide information to residents to remind them that they should keep fire doors shut. And that's, not just cross corridor or final exit corridors, but also their flat front doors, which are fire doors. Also that they mustn't mess around with any self-closing devices, and any faults or damage that they have come across or they have caused, they should report immediately to the responsible person. And again, the information in relation to fire doors should be provided to residents either when they move in or as a minimum annually, and whenever there are any significant changes. So those information requirements exist for buildings of any height. But as you get into a bigger and as the regulations would consider a slightly higher risk building, then additional regulations apply. So for any multi-occupied building above 11 meters in height, there is a requirement under Regulation 10 to undertake quarterly checks of all fire doors. And these are fire doors in the common parts, and that includes the self-closing devices. So this is not a specialist or technical exercise where, you may need external expertise. This is more visual checks, making sure that there is no damage, that they are in full working order, that the self-closers work, etc. In addition, there's a requirement to undertake annual checks on flat entrance doors, and that includes self-closing devices where they lead into a building's common parts. So they may come into a protected hallway, etc. And that's on a best endeavor basis. So the regulations recognize that people may not be either in or present, or they may not be particularly happy about letting you come in to have a look at the flat entrance door. So in essence, in relation to this, what you must do is try and record the attempts that you have made in order to undertake that check. And that will then assist you in trying to explain that you have done what you could, that you should be doing under the regulations. Excuse me. Now, as you may imagine, for higher buildings, for bigger buildings where there is greater risk, and bearing in mind where these regulations emanated from, there are much more onerous requirements for what are known as high-rise residential buildings. So these are buildings where, again, there's 2 or more sets of domestic premises, but it's either 7 stories above ground level or at least 18 meters in height. And the reason or the rationale for there being extra measures required in relation to this is due to differences in building standards, but also the firefighting strategy that may be need to be applied for a high-rise building. So what do the regulations require? Well, Regulation 4 requires that a premises information box is installed, and this has to be somewhere accessible to the fire services if they were to arrive at the building. So it should contain contact details of the responsible person and anybody else nominated or designated by the responsible person. And it should have copies of floor plans, which specifically highlight where key firefighting equipment, such as evacuation lifts, dry rising mains, etc., are. And in addition, a single-page building plan. So in essence, hard copies of documents that will help the fire service when they arrive at site in an emergency situation. Firefighters would have to have access to that, and like any other sort of protective or fire safety measure under the fire safety order, the premises information box has to be kept secure but also maintained, and everything within it needs to be kept up to date. Regulation 5, and again, this applies to high-rise buildings, so your 18 meters plus. You have to provide information about the design and material of any external walls electronically to the fire and rescue service. Now, there is a template available to do this, and there's also guidance available on the YouGov website, which explains how this can be completed. But ultimately, the content of that template and the information you provide is likely to derive from any fire risk assessment that you have had undertaken, which, as you know, from the Fire Safety Act, also needs to have an assessment of fire safety risk from the external facade of the building. In addition to providing that information, any material changes also have to be communicated to the fire and rescue service, and the information that is provided should also explain the level of risk that the external wall structure, because of the materials and its design, poses, and any other steps that you've taken to mitigate that risk. And again, that should emanate from your fire risk assessment. I mentioned about floor and building plans earlier in the context of a premises information box, but Regulation 6 specifically requires that floor plans identifying key firefighting equipment, which is listed in Regulation 6.7, are prepared. And a plan needs to be prepared for every floor unless each floor is identical in terms of where everything is and the layout. In addition to floor plans, a single-page building plan has to be prepared, which again includes all of the necessary key firefighting equipment, which is listed in Regulation 6.7. And these are fairly simplistic plans, easy to view, that would enable firefighters to grab a hard copy from the premises information box and sort of decide on the strategy for tackling any emergency situation. Under Regulation 7, the responsible person has to undertake monthly checks of lifting equipment, so lifts that are designed and installed either to be used by firefighters or in the event of evacuation during a fire. Also have to take monthly checks of any mechanism which enable firefighters to take control of such lifts, and also key firefighting equipment, again, which is listed in Regulation 6.7 and includes things like dry rising mains, wet mains, inlets, etc., fire alarm systems, alarm panel, and so on. If there are any faults to any of the key firefighting equipment or the lifts, then they must be rectified as soon as possible. And if it looks as though it's a big job and it can't be done within 24 hours, then the local fire and rescue service have to be informed by through an electronic portal or whichever means you have to communicate with them, whether that's email. You also have to notify your residents of the outcome of these monthly checks. So there's a requirement for transparency, and that may include either posting them on a notice board, or if there's some kind of residents intranet, or even making them available to a residents association. So that's about giving, if you like, residents reassurance that these checks are being made. During the Grenfell Tower fire, there was a significant problem with firefighters losing their bearings. They didn't know where they were. They didn't know which floor they were on. They didn't know how to gain access to certain flats. And one of the failings identified during the inquiry was that the signage was very, very poor, and people couldn't see it or read it in difficult smoky conditions, which of course most fires would be. So Regulation 8 it sort of provides a requirement that a responsible person installs clear signage with floor and individual flat numbers clearly identifiable for all high-rise residential buildings. I mentioned about providing documents to the local fire and rescue service in advance, and there is a template to do all of this. But yeah, as I mentioned earlier, this has to be done in relation to both external wall systems, but also floor plans and single-page building plans have to be sent to the fire and rescue service in advance. This gives them the opportunity to consider whether or not a certain approach would be needed to tackle a fire in that particular building, whether they need any further information, and so on. It just enables them to be more prepared in advance should an emergency occur. So I mentioned that as a building increases in height, there are more and more regulations that apply, and this is just an easy sort of at a glance way of seeing which regulations apply depending on the type of building. Now, having covered things that are already in place and have recently been introduced, there are a number of other issues that are, if you like, bubbling under that we expect to see changes in the near future. And one of those is in relation to personal emergency evacuation plans, or PEEPs. Now, one of the recommendations arising from Grenfell was that responsible persons should prepare PEEPs for those individuals who may be disabled or have mobility issues and will be unable to evacuate out of a premises on their own. Now, this is still going through various consultations. It's been the subject of multiple consultations, and the government have yet still got to a stage where they can agree what needs to happen going forward. The difficulty is that in relation to residential premises, particularly those where they're not necessarily supported living or may not have anybody on the premises, that it's how do they take the information? How do they get information about the fact that somebody might not be able to self-evacuate? People might not be keen to share that information. But in addition, even if you then had that information, what happens if it's a multiple occupancy block of flats where you have no presence? You've got no individual working there. You know, what would happen if you did have somebody working there? Would they be under a particular obligation to go up and down flights of stairs repeatedly, trying to evacuate numerous people who wouldn't be able to do that themselves? And that causes a whole lot of problems. You know, you may be sort of going against the traffic, as it were. If there is a simultaneous evacuation strategy, you're running up a fire stairs when everybody else is trying to evacuate it down it. And if people are being evacuated by neighbours and things like that, during the course of that evacuation, they may cause delays to able-bodied people trying to evacuate as well. Now, of course, that assumes that it's not a stay-put strategy where people have to remain in their premises, but it's an ongoing problem. Another area where we're expecting significant change is in relation to fire risk assessor competence. Now, under Article 9 of the Fire Risk Assessment, a responsible person has to have a suitable and sufficient fire risk assessment in place to ensure that they can take all appropriate measures and protect individuals. The problem with that is that fire authorities also look at who has developed that fire risk assessment. So if a fire risk assessor doesn't have the necessary competence, and for whatever reason the fire risk assessment is not suitable and sufficient, well, that's a problem for both the fire risk assessor but also you as the primary duty holder. And so one of the things that fire authorities always look at is to what extent have you as a duty holder looked at and tried to understand the competence of the person you're engaging to do the fire risk assessment. Now, the fire safety order itself doesn't actually define what competence looks like. And at the moment, the government is really sort of wrangling with this, particularly in relation to introducing fire risk assessor competence issues under the Building Safety Act, because they've recognised that, again, risk assessor competence is not specifically defined anywhere. So what we are anticipating at some point in the future is that there may be certain competence requirements that will be fairly objective. So that may be things like the need for certification through an appropriate body, whether the Institute of Fire Engineers or somebody else. Now, that may be limited to high-rise buildings that would be caught by the Building Safety Act, and the sort of high-rise residential buildings, sort of 18 meters plus from the fire safety regulations. But at the moment, that's still very much up in the air. So when you are looking to engage a fire risk assessor, I think the main thing to look at is guidance that's been produced by the National Fire Chiefs Council, which explains the type of checks that you should be undertaking in order to appoint somebody, particularly when they're external. Finally, the Building Safety Act. It started to come into force. Obviously, the act has been passed, but the main provisions under the legislation are being sort of brought in a piecemeal way by various regulations. It's a vast piece of legislation, and it's very difficult to kind of cover everything at this stage. But one thing to bear in mind is that if you do have a building that meets the definition of a high risk building under the Building Safety Act, so an 18 meter plus or 7-story building, that there is a requirement that you register that building, if you're an accountable person or the principal accountable person, with the building safety regulator. So the registration regulations came into force 2 weeks ago on the 6th of April, and the information that needs to be registered, that you need to record and provide, is set out in the higher risk building key information regulations. And I've put those regulations on the slide there for you. So the registration requirements, there will be a fee to pay, and if you don't pay the fee, it will deem as though you've not actually registered. But the registration window is only open until October. It might be that what we will do is provide a further sort of standalone Building Safety Act type webinar at some point in the future. So that's it. That's a very quick whistle stop run through recent fire safety changes. I am aware that there may be some questions, and happily Estelle has provided one on the smoke and carbon monoxide alarm regulations. My belief is that it doesn't include long leases, and there may be specific provisions around ownership leases, but unfortunately it's not very well defined in the regulations. So that might be something I'd have to have a look at in a bit more detail. If anybody else has any further questions, please feel free to pop them in the Q&A box. I'm just going to leave it a little bit in case somebody's as slow at typing as I am, which is fine. Okay, I'm going to assume there are no more questions. So thank you very much for attending. And like I said, I may look at sort of providing a Building Safety Act specific update in due course. So if that's something you'd be interested in, please contact me and let me know, or let Estelle know. Thank you very much for attending.